Appeals Division 1 is now in session.
Good morning. Thank you. You may be seated. We are here this morning in Dunklebarger versus the Industrial Commission of Arizona. It's our case number CA IC16 0070. Each side will have 20 minutes for argument. Counsel for petitioner will be responsible for reserving any time you might wish for rebuttal. These proceedings are being audio and video recorded, so we would ask that you state your name and your client the first time you approach the podium. We have conferenced this matter. We've read the briefs, and we look forward to your arguments. And with that, you may begin.
Thank you, Your Honor. May it please the Court, I'm Darrell Engel of Jerome Gibson Stewart. I represent the petitioner, Roy Dunklebarger. I would like to reserve some time, hopefully 5 minutes of for my time. This case involves a 22-year veteran police officer who was employed by the city of Mesa and who was found not only by his own treating doctor but by the defendant's doctor to have an acute stress disorder based on his work environment at the city of Mesa, based on his work at the Internet Crimes Against Children Unit. The purpose of the Workers' Compensation Act is to protect and to help the injured worker and his or her dependents, and that's true of the Constitution as well. But for a mental injury case, we also have an additional requirement that the event must be unusual, unexpected, or extraordinary. It does not require the event to be unique. What was the environment that Mr. Dunklebarger was exposed to? When you read opposing counsel's brief, it indicates that he saw some images of sexual contact between children and adult men. I just want to read a couple of lines from Mr. Dunklebarger's testimony. What type of things were you seeing? Little girls, clearly no development. One of the images was a little girl that was on her back looking up at the camera, while another, she was probably about 11 or 12, while another 11 or 12-year-old boy was penetrating her in a missionary position. There were other images of little girls on adult legs of males, adult legs with the male's penis exposed, and she would be holding onto it or be licking it. There was another image where one little girl that was probably 7 or 8 was sitting on top of a naked adult male with his erect penis, and she was holding about 3 or 4 other pictures of male, naked males' erections, those kind of things. Question, okay, yes.
Were the other 5 members of the unit, were they also looking at the same or similar type of images?
Yes, they were.
And if we're looking at a unit, why wouldn't we use just that unit since they were all involved in the same type of activity?
Because if you just look at the unit and everybody's looking at those images, then no person could ever have a compensable claim.
Well, that's not true, is it? Because you could have such a horrendous case, one case that was just horrendous that would cause one member of the unit to be unduly stressed.
Well, this is the problem, Your Honor. Let's say that of the 6 members of the unit, that my client was exposed to these images for 60% of his time. And let's say 4 of the...
Not this case, though, right? Because he only handled 15 cases, correct?
Well, I was about to finish the transcript, which indicated he viewed those images for 4 to 5 months.
Well, but we're talking about 15 total cases. Isn't that what the testimony showed?
That's what the testimony indicates in terms of the number of cases, but he viewed images 40% of his time for 4 to 5 months.
Were those images different than what the other members of his unit were viewing?
No, but what I wanted to explain was that if we only confine this analysis to the unit, and let's say that my client viewed these images 10% more than most of the unit members, but 10% less than, say, one other member, would my client then have no case?
Let's talk about the facts of this case. Of the 6 members in the unit, wasn't he viewing the lowest amount of cases as it relates to child porn?
Overall, yes, that's correct.
Okay, so it wasn't a situation where in this unit he was given an extraordinary amount of cases to review, which would have been different than the other members in the unit.
Well, I think extraordinary goes more to the nature of the exposure. And my position is that when you look at my client was hired by the Mesa Police Department as one of 775 officers. Out of those officers, only these 6 were exposed to this type of environment. And what I'm saying is that if you look at the cases, the cases talk about librarians. They don't talk about special librarians. They talk about teachers. They don't separate it into special education teachers. And so my argument is that we should be looking at all the police officers.
Aren't some aspects of what police officers do necessarily more stressful than what some officers do? Maybe a community liaison officer might not be subjected to the same type of stress that someone on a SWAT team would be subjected to. Can we really just compare the entire police force? Isn't everyone's job necessarily more stressful in at least one aspect of policing?
Well, that may be true, but in this matter, when you talk about a community liaison person, that person may also have been a SWAT officer or a patrol officer at some other time, just like my client. My client was an officer for 22 years with the city until he was brought into this unit.
Well, but I think you're missing the point of the question. The question is, why would we be comparing a community liaison officer's stress with that of someone who's on SWAT, with someone who is dealing with reviewing the child porn cases?
Well,
aren't they just completely different jobs?
They have different aspects to the job. All the police officers are hired to protect and serve the public. But what I'm saying is that typically, as in my client's case, he was a patrol officer for a while. He was a SWAT officer for a while. He worked in forensics, but not child forensics. So what I'm saying is, I think the logical thing would be to look at all officers and see, is this unusual? Is viewing these images unusual in the context of being a police officer with this department?
Wouldn't it make more sense to say, would this be something that a police officer might be expected to do in this department? I think the argument would be more compelling, it seems to me, if there had never been a child porn unit and one person is asked to do it. But this has been there for a while, and this seems to be an assignment that police officers may be given. So it doesn't seem like it's necessarily something unexpected. This is part of policing the community. Sorry, go ahead.
No, sorry. Well, let me address that, because that is one of the possibilities under the statutes, whether or not it was unexpected. The administrative law judge, she found that he was aware of the expected content, but that could not be further from the truth. In her own finding number 4, she stated that he expected to see pornographic type images, but had no idea how toxic it was going to be. He had not seen prior images of child pornography. The training that he had did not include any child pornography images. The training did not include how to deal with dealing with child pornography images. And even the defendant's IME physician found that this was an unexpected environment for him. So I think he met that criteria.
Personally. It was an unexpected environment for him personally.
Yes.
Well, aren't we looking at an objective standard here?
We are looking at an objective standard, but she's only examining him, and she can only comment about her examination of this gentleman, and she found that he was in an unexpected environment.
But what do we do with the language from Barnes that said a reasonable person's sitting next to this person doing the same type of work? If he's the only one, does that comport with that standard from Barnes?
I think it does. I don't think that the judge ever decided whether or not there was an objective basis for this condition. She had incorrectly determined that because no other member of the unit had suffered this way, that he had a subjective reaction. That was incorrect based on the only testimony that was taken. That was by the defendant's witnesses, his supervising sergeant and fellow officer, who both testified that at least one other member of that unit had a reaction to viewing these images.
I thought in that instance, everyone, whatever case that person had worked on, everyone who had worked on that case was referred for counseling. Doesn't that suggest that there was an exceptional case as opposed to in this one where it doesn't seem the entire department was referred for counseling? It's one person.
As I recall the facts, it was one person who had suffered a reaction from viewing these images. Whether or not other people were sent for counseling, many times that's a standard procedure to be sent for counseling when there's a certain event, particularly in shootings, for example. But the testimony is that there was one person who had an adverse reaction, and that's contrary to the judge's basis for her decision.
What do we make of? Was there some testimony to the effect that that some of the stress may have been tied into the fact that something similar had happened to his wife? Doesn't that seem to suggest it's more personal to him than an objective standard from a reasonable person sitting next to him?
It could have. That was sort of an underlying fact. But the IME physician, Dr. Johnson, she diagnosed him with two conditions, acute stress disorder and anxiety, and she indicated that those were related to his work environment. It's just sort of like someone who comes to work with a bad back and then lifts a box and now his back is worse and needs treatment because of the work activity.
Well, except that's a personal thing. It's not objective standard. That's the individual has a pre-existing condition that would take it out of the realm of being an objective standard, wouldn't it?
That would in that instance, but I'm just giving an analogy.
I thought you were saying that was the equivalent of what happened in this case, that he had a pre-existing condition being with his wife, and ergo when he observed this material, that's what caused the injury.
No, then I misspoke. I'm not saying that he had a pre-existing condition. There was an event in his life that he made the doctors aware of. He didn't receive any treatment for that. That was not an ongoing issue for him whatsoever. Had it been, he probably would have declined going into this unit if he had an option. So that's just something in the background. But my point is that the doctors both decided that he had this condition based on this work environment.
Then I guess that begs the question of whether it was from an unusual or unexpected source. There's no disputing. Both sides agree that he personally had it was very stressful for him. But if it has to be something unusual or unexpected, that seems to be a different question than do we agree that he was accurately diagnosed with this stress condition? Right,
and so what I'm saying is that it's unusual in the context of him being a police officer, as one of the 775 officers, that all of these members, these 6 members who are subjected to this, that's extremely unusual given the context of the overall police work that he was hired to do. I'm also saying that, as I described earlier,
would that eliminate one aspect of what the police department has to do if everyone on that unit is subjected to something that's clearly more stressful than other duties that police officers perform? How could you ever have someone carry out that function if this particular function is just unusually stressful and so unexpected? Wouldn't they all qualify?
Well, if they all reacted, there's no requirement that any of the other people react. So when the judge decided that no one else reacted, that was wrong. But the statute itself doesn't require anyone else to react. When we look at the cases that were cited by both parties, there's no other instance of a second person having to react. Basically, those cases are decided whether or not there was some change in the stress that employee was subjected to.
But it isn't relevant, though, because we agree that he reacted and reacted appropriately and it suffered a stress condition. But if no one else on that particular unit reacted in that way, then it's hard to say that it was an unusual event that caused the stress.
Well, what I'm saying is that the unusual should be looked at in the context of all of the police officers, not just this unit, because otherwise then you get into my scenario which I gave earlier, if my client has been exposed to 60% versus 50 versus 70, then is it only the fellow who has 70% has a valid claim? And so that's why I think confining this to the unit is inappropriate, and I think the cases support that.
What's your best case for supporting that proposition?
Well, if you look at the Tucson Unified School District, in that case, it was a special education teacher who had claimed some type of harassment by his supervisor. The court did not analyze that case in terms of special ed teachers. They looked at all the teachers. Likewise, in Pima, which involved a librarian.
Wasn't that a teacher who was treated differently by the supervisor, differently than other similarly situated teachers?
Teachers, but that's my point, Your Honor. Teachers, not special ed teachers. So they didn't confine it to one unit. They looked at all teachers.
But there wasn't a disparity, and the claim was based on how she was being treated, not on the nature or circumstances of the job.
True, but the question, my point is, the question was the comparison to other special ed teachers only, or was it to all teachers?
But it wasn't an issue in that case. That's what I'm asking. It didn't appear that that was an issue in that case.
But the question was whether or not this person was treated differently by the supervisor. And so the court did not look at only special ed teachers. It looked at whether or not he was treated differently than other teachers. And so that's analogous to my argument here.
That seems like it's just an employee of the police department who's the receptionist is not given vacation times, not being treated equally. That seems very different than the stress from the job, that just being treated unequally. Mm-hmm. That case seems very different.
Well, it may be in terms of the facts of the case, but in terms of the principle, what I'm saying is that the courts, when we look at these cases, looking at all officers, all librarians, all education teachers, not confining it to a particular unit, which my client happened to be in for a short period of time in a 22-year career. I only have a few minutes left. I'd like to reserve some time. Thank you.
May it please the court, my name is Todd Lundmark, representing the respondent, City of Mesa. I'd like to start with a few comments about the legal authorities that Judge Lavelle had to consider in her analysis of this case. First, for mental injury claims like this one, the idea that medical causation evidence alone is not enough, that we need more evidence to link the condition with the work, is not an idea that originated with the legislature, with our statute. It originated with our Arizona Supreme Court. This legislation became law in 1980, but in 1978, the Arizona Supreme Court decided a case called Sloss versus Industrial Commission, which coincidentally involved a police officer. In that case, the allegation was that the stress and strain of being a police officer, in that case a DPS officer, had made this person ill. The Arizona Supreme Court, admittedly without a lot of analysis, rejected the idea and held that for a condition like this to be compensable as an injury by accident, we want proof of the unexpected, the unusual, the extraordinary stress. When our legislature enacted 1043-01B a few years later, it incorporated that language in that word order verbatim. It's perhaps one of the few occasions we have a policy that's enunciated both by the judicial and legislative branches of our government. The second,
could there be a case, let's say just in the universe of child porn cases, could one of the cases be so egregious that it would meet that standard, or do they all simply fit within that category of difficult to watch?
That's a different case from ours, and I noted your question earlier because I have a similar case on my desk where a sex crime detective who had been doing it for many, many years reacted to an especially egregious case, and we're trying to sort out how to handle that case. It's a difference of degree and not of kind, because he'd handled those cases for many, many years, but this particular case really got to him, as it did to everybody else who investigated it. I'll have to reserve that to a different time, but I think that may be a point well taken. It's simply not our case. The second point I wanted to raise is this. 1043-01B became law in 1980. In 1988, this court decided the Barnes case. And in the Barnes case, the court, citing back to Archer, which was a pre-statute case, held pretty emphatically that in these cases we apply an objective standard, not a subjective standard. It's been almost 29 years since the Barnes case came out. Legislatures never revisited this issue, which is a silence that suggests some degree of acceptance of that idea. These are the authorities that Judge Lavelle used, and here's how she analyzed the case. First, on the issue of whether this officer had been subjected to stress that was unexpected, I don't quite understand why, even on appeal, the claimant continues to argue that he really didn't expect this. His own testimony was that he did. He met with Sergeant Bina before he moved into computer forensics. They talked about the fact that working with the ICAC cases, working with cyber crimes, he would be exposed to some of this material. That was never a secret. He knew it from the very beginning. Judge Lavelle found as a fact in this case that this was not unexpected because the officer knew before he moved into this unit that this would be the kind of material that he might be exposed to.
Well, except until you actually see it, do you really know how it's going to affect or the kind of stress that it's going to bring upon the person?
I agree with that completely, which raises a second issue that Judge Lavelle had to address, which was to what extent was his reaction idiosyncratic? To what extent was it subjective? We had some pretty strong evidence on this point. The claimant himself admitted that at one point he started seeing his wife's face on the images of these kids because his wife had apparently been molested as a child. He'd never gotten the details, but he couldn't get it out of his head. His testimony was, yeah, I expected to see this stuff. I just didn't expect it to be as toxic to me as it turned out to be. That's a strikingly subjective reaction, which is not enough to meet the legal criteria under our statute. The judge made that finding, and in her report, Dr. Johnson, who was our expert, said he has an acute stress reaction related to his exposures, compounded by his own personal experiences with his wife and his reaction to this material. That's exactly the kind of case we're looking to weed out when we analyze these cases. The single most important factor that Judge Lavelle had to consider, and she really considered it in her decision upon review, was the one I think you've touched on repeatedly, which is, in this very unit, was this officer's experience any different from the other officers? And on that point...
Can I ask you this?
Yes.
What if there were only one person in this unit? Would that qualify? Who would the comparison be to in that instance?
You know, I've had that case, and it didn't get on appeal, but I had a case for Lake Havasu City involving a crime scene investigator. He was the only crime scene investigator for the city of Lake Havasu City, and he had a reaction to some of the cases he had handled. What you would say, you know, using a simplistic analogy, well, he meets the standard. What we had to do in that case was to ask, well, what do crime scene investigators generally do? What can they expected to be exposed to? So that's my best answer to your question. If we had one member of computer forensics who had to handle child pornography, we would have to analogize to other police forces around the city and around the state and the country.
Okay, so if there's two and one person just nothing seems to faze them, that's the objective standard with the reasonable person sitting next to him, but it's one person. Do you, in that circumstance, would you do the same thing and look to maybe other cities or other jurisdictions?
I suppose so.
That's your point?
Yeah, I would start, as I did in this case, by asking, okay, child pornography, I've never had a case like this. How much does this get involved in the work these guys do? And what we found was not only were these cases being signed fairly randomly to each of the 6 officers, but when it became clear that he'd had less training in computer forensics than the other detectives in this unit, Sergeant Bynum said, I started giving him fewer of these cases. He doesn't meet that objective standard on the facts of this case. But to counsel's point that we really ought...
Fewer is important to whether a particular case might be more extreme than another, if we're talking unusual or unexpected. Assuming the workload's just even or lowered, I mean, it doesn't But I assume there's no evidence in this case that the ones he was looking at were more extreme than what the other members of the unit were looking at?
Not at all. He never argued that a particular case got to him. He never argued that the kind of cases he dealt with were somehow different or more egregious than the cases the other people handled.
Well, did he concede this morning when I asked him a question about when he was that they were similar to what others had made?
Exactly, and that's ultimately why we're here on this particular single issue, which is whether the comparison should be made not between the members of this particular unit, but this officer and police officers in general. I suggest if you do it that way, you really frustrate the objective standard of our statute.
Let's talk about that for a minute. How could we ever do that when we have such a wide variety of responsibilities from our police officers?
I don't know how we could, because in a police force as large as the city of Mesa is, we have lots of different work groups. So if you broaden the analysis in the same cases on my desk, I have to ask, well, where do I start? If I have to go beyond computer forensics to ask, well, how about sex crimes? They have a sex crimes unit. How much of the time do these guys actually get exposed to child pornography? The testimony in this case was occasionally they do, but that's not primarily what they do. It was pretty unique, and that was the judge's holding in our case, that this was a unique unit that was devoted to investigating cybercrimes. And there's no way to analogize that to any other work group in the city of Mesa. I think one of you articulated the language from Barnes.
They actually spend less than 50% of their time doing this type of case.
Well, that was the other point, certainly. The idea that they were doing nothing but looking at these images all day was not the case. It's part of what they do. It's probably less than half of the time, half of what they do. And in this officer's case, it was even less than that at the end. He just had a reaction to working with this material, and I've never disputed that at all. It's never been our argument that everybody else had to get sick as well for him to sustain his claim. That was rejected in the Barnes case. Clearly rejected in the Barnes case. But our point all along has been, if you compare his experiences with that of his peers, they were no different. He does not meet the objective standard. That, plus the fact that we have ample evidence that he had a very personal, subjective reaction to this material, ultimately led to Judge Lavelle's finding correctly, we think, that this claim would not be compensable. And we would urge the court to affirm that award.
If you had, I know this is a hypothetical, but if you had a situation where more people in the unit were coming down with this stress disorder, would that indicate that, in fact, this is a claim that can be found under the statute?
I don't know how to analyze that. Let's just say hypothetical. Everybody, all 6 detectives filed claims.
Make it that, say a third, historically a third of the unit came down with this kind of disorder.
I can tell you my clients would have the same answer. This is their job. This is what they are hired and trained to do. It's not unusual. It's not unexpected. It's not extraordinary. This is their job.
If a third are getting it, wouldn't that mean it is typical? I mean, I don't know. It just seems to me that this, I mean, I realize it's not this case because we have one person that has suffered from this disorder in the past.
I don't have a good answer. If we had that case, we'd have to look at it very, very carefully. I suppose it's possible to posit that we human beings can reach a limit, most of us, and there's a certain category of cases that are so terrible that no human being can possibly be expected to weather it without some sort of emotional damage. Maybe that case will come up.
At least be evidence that would be considered if
Sure.
Everyone else, it would suggest that it was there was something unusual or extraordinary about it.
Let me tell you, just personally, we're starting to see these cases more and more, and I think the court will see them, and I think Mr. Engel will join me in this. We're seeing more and more PTSD cases involving first responders. We're really struggling to deal with them. Part of the problem lies with the medical profession and their standards for diagnosing these conditions. I think you're going to start seeing the kind of cases you've posited, but it's simply not our case. Our case seemed to be pretty straightforward to us. That concludes my remarks. All right, thank you.
Thank you. A moment ago, Judge Cattini asked opposing counsel, what if there was only one person in the unit? Then he said they would look elsewhere. And then the follow-up question was, what if there was one person reacted out of a 2-member unit? and Mr. Lundmark indicated that you would go beyond the unit. If you go beyond the unit there, why are we not going beyond the unit here?
Wasn't he suggesting, though, that you go beyond in that you're comparing other police departments that have officers who perform a similar function? Isn't that a more similar group than, say, the community liaison for an elementary school?
None of the cases that have been cited go to that level. They all look at co-employees within a particular employer. None of the cases go to some other employment.
But most of those cases, though, still look at what the functions are. I don't see where you've cited a case where the issue in the case was the disparity of the functions between the different employees.
I'm not.
Such a case?
I'm not sure if I understand. I'm not sure if I understand your question.
You talked earlier about the Tucson case, the special ed versus regular, but that wasn't an issue in that case. If you're talking about the function of the employee, and in this case we're talking about computer crimes, versus the community liaison officer, why would we compare those two? Those aren't at all similar. I mean, why wouldn't we compare the function of the employee between what job they're actually performing?
Well, for the reason I've given earlier, but additionally, as I've indicated, these are all police officers within the city. They all have different duties. But looking at these images in and by itself are extraordinary. As Mr. Lundmark indicated, there was another sex crimes unit part of the city, but did not look at any type of images to this extent. So what I'm saying is the nature of this in and by itself is extraordinary, and that should be taken into account. And if the policy of the state is to liberally construe these matters in favor of the injured worker, then this would certainly be the case to analyze it looking at all officers rather than confine it to one unit with all the problems that I believe engenders. Thank you.
Thank you both for your arguments. It's an interesting case. We will take this matter under advisement and issue a decision in due course. With that, we're adjourned.